So on line 64 and 65, where it talks about an execution, that execution is a process that they have to go through at any point when they are pursuing a delinquent taxpayer. So we're not having the Department of Revenue simply claim IO and then seize my assets. There's a process that they have to go through to accomplish that.
That's my understanding.
Probably, I would assume, has a chance for, response and probably hearing and whatnot, and for the person whose assets are being identified to come forth and have due process, basically. Yeah.
Simply about efficiency and execution.
Okay. All right. All right. Any other questions for Representative Saints about House Bill 452? Is there here? Do we have anybody signed up to? We do not have anybody signed up. Nobody wants to talk today.
Motion
All
do
right.
pass.
There is a motion to pass for House Bill 452, and there is a second. Is there any further discussion? Hearing none, all those in favor, please indicate by saying aye.
Aye.
Any opposed? You are off to rules, Mr. Saints.
Thank you.
Thank you for being here.
Appreciate it.
Enjoyed our time together.
Come back.
Maybe. Thanks, Steve.
All right. Okay. Alrighty. I think we have several bills that we have subs pending that aren't quite ready yet. I had talked to Mr. Reed about this earlier, and we had decided that we probably would have to recess at some point to allow Ledge Council to get those subs, which have been worked on and perfected by subcommittee, but they just had to have time to get us those copies here in the full Judiciary Committee. I think the only other one that you're saying, Mr. Reed, that is ready is Ms. Silcock's bill. Is that 247, HB 247? But I know that she had a prior couple of things that she had committed herself to do around the Capitol, including her one thing that relates to her committee she chairs. So if we have nothing else at this time, so, ladies and gentlemen of the committee, Mr. Reed has told me that he thinks that he can have some subs for us from Ledge Council, and also he can report to the clerk's office the bills that we've already dealt with. So we will stand in recess until 12:15. 12:15. Looks like Chick-fil-A to me. pass them out as we move forward, and take a pause whenever we need to make sure we've got all the appropriate subs in front of you. But we do have one that should be in front of you, and that's Representative Hawkins' bill. Chairman Hawkins, you want to come forward?
Yes, sir. Thank you.
And tell us about House Bill 296.
Yes, sir. Thank you. Our DA, Lee Darrell, has
And just for the sake of those keeping records, House Bill, I apologize, Representative, House Bill 296 is one that the chairman is adding to the agenda because apparently there was a slight mix-up on the request form, but nonetheless, Representative Hawkins checked with me, and it's after you hear it, I think you'll understand why I didn't have no trouble adding it. Go ahead.
Mr. Chairman, to the committee. House Bill 296 addresses a term of court. This was asked for by our DA, Lee Darrell. This involves Hall and Dawson County, and so you have before you House Bill 296. There is a slight amendment on this bill because actually it's an error that occurred in Legislative Council. On line 11 after Hall County, it says first Monday. That should say second Monday. And this is what the Chief Judge, Kathleen Goslin, has requested in her letter and agreed to also. So I'd like to make the change on line 11 after Hall County, strike first and replace that with second Monday.
And we'll make that amendment for you at the appropriate time. And what you have there also, Representative, is a letter from your Chief Judge
Yes.
indicating that the judges in the circuit would desire a change in their term of court for Hall County, and also you've spoken with your prosecutor, your DA, and they're in concurrence. Is that right?
Yes, sir.
Okay. So let's see if anybody has any questions for you on House Bill 296. Is that Representative Holcomb? No?
So it was an accident.
Okay. All right. Anyone here wanting to testify regarding House Bill 296? I don't think we have anybody signed up. Any further questions for Representative Hawkins from the committee? Okay, hearing none, we'll bring that back to the committee. Is there a motion regarding House Bill 296? There's a motion and a second, a do pass by sub, and there was a scrivener's error on line 11. Representative Hawkins, they didn't want to start on the first Monday, but the second Monday. Is that right?
Correct.
Did they tell you why? Somebody got Rotary Club or something on the first Monday? Or?
Happened in lead council.
Okay.
Yeah.
All right. Maybe Let's Council does. Okay.
Well, the request
All right.
was second Monday.
Absolutely. No problem with that. That's an easy fix. So the amendment would be on line 11 to change the word first, so the first Monday to second. Is there a motion that amendment be approved? There's a motion and a second. Any discussion on the amendment? Hearing any objections to the amendment? Hearing none, that will be in. And now we're back to the main bill. Any further discussion on House Bill 296 as amended by committee substitute? Hearing none, all those in favor say aye. Aye. Any opposed? You're off to rules.
Thank you, sir.
Good luck.
Thank you. Appreciate
Tell
it.
your judges
Thank you,
you were down here working hard for them.
I'll do it.
All right.
And your father-in-law.
Absolutely. Okay. while we're passing out Representative Holcomb's bill, the chair would announce that House Bill 311, which is a bill dealing with sovereign immunity, we will take that bill up Monday afternoon, upon adjournment, or 2 o'clock, whichever is later. Representative Welch has some additions that he's working on that for us, and he's going to do that over the weekend instead of practice law and see his family. We appreciate you. So if you're here for House Bill 211, we will do that on Monday upon adjournment or 2 o'clock. I said 211, 311. I'm sorry, House Bill 311. House Bill 311. We'll do that on Monday upon adjournment or 2 o'clock, whichever is earlier. Yes. All right. While we're also getting those copies made, I want to recognize some of our judges that are here with us today. We always appreciate their presence. Judge Guy, where are you? There you are, right there. Okay. You're not driving back and forth, are you? You just okay, good. But we appreciate you. Brunswick's a long way off. Thanks for coming up here and visiting with us. Judge Mara, there you are. Good to see you, sir. We appreciate you being with us today. How long does it take you to get here from the Flint Circuit?
Just 30 minutes.
30 minutes. Long way. Yeah, we appreciate it. Yeah. We know that you could be doing other stuff, so we thank you for being here with us today. Thank you very much. And I believe we have Judge Betsy Kidwell, the Magistrate Court of Heard County. Judge, how are you doing? Good to see you again. Thanks for being here today. We appreciate it. I think we were gonna, was it Scott that said that we delayed on the floor this morning?
I don't know. I wasn't able to watch.
Okay.
Now here's the thing.
Uh-huh.
Did we already vote on this?
Okay. All right. Everybody got House Bill 230 in front of them? Representative Holcomb's bill. Representative Holcomb, why don't you tell us about House Bill 230?
Thank you, Mr. Chairman. This bill will allow Georgia to provide for benefit corporations. It is a corporate structure that has been around for some time. It's now approved in 33 states as well as the District of Columbia. And the meat of the bill is on the second page. And benefit corporation is defined as a corporation whose articles of incorporation contain a public benefit provision and a statement that the corporation is a benefit corporation. And the real, I think, general way of explaining this is it is another option for entrepreneurs that want their companies to have a purpose that is other than just maximizing shareholder value, which is the traditional definition of a corporation. So they would choose to be a benefit corporation that would then have purposes that benefit the public and society, either through cultural, charitable, educational, etc. But this is not a nonprofit. It is a for-profit company and entity, and the legislation, which has passed the Judiciary Committee the last 2 sessions but didn't make it further, was drafted by the State Bar's corporation section and recommended by that section, and it lays out what the requirements are for the company in terms of the board and then the other corporate requirements. And I'd be happy to answer any questions if there are any, Mr. Chairman.
Okay. Questions for the author of the bill for House Bill 230? Any questions? And Representative Holcomb, I believe you and I discussed before, and I believe you referenced this. This is exactly the same bill that we've passed previously. Is that correct?
Yes, sir.
Absolutely. Thank you. All right. Do we have anybody signed up for House Bill 230? Wants to discuss it? We do not. Okay. Is there we'll bring it back to the committee now. Is there a motion regarding House Bill 230? There's a motion and there's a second. Any discussion? Hearing none, all those in favor of House Bill 230, please indicate by saying aye. Aye. Any opposed? You are off the rules. Have we got Representative Lunch? Representative Lunsden, we're checking now to see if we have the copies of the sub made. House Bill 387, why don't you tell us about that?
Mr. Chairman, members of the committee, bring to you House Bill 387. It's a bill that deals with private nonprofit volunteer fire departments and conforming liens. Approximately 25% of the fire service in Georgia is provided by private nonprofit volunteer fire departments. Most are structured as 501(c)s. A substantial number are subscription-based services. Property owners who subscribe to the service pay an annual subscription fee, and in the event of fire, the department responds. Property owners who do not subscribe may request the fire department respond to a fire, but they do so knowing they are responsible for costs associated with putting out the fire. In the event the owner does not pay for the service requested, then this bill simply provides for a means of collection at a future date by placing the cost of the service on the list of conforming liens as listed under Code Section 4414-320. This is a committee substitute, LC 411912S, and the only addition was some language that tied those costs or those charges to a FEMA list of standard charges per hour.
Thank you, Mr. Chairman. And so as I understand it, I was looking around my table here and thinking which of you might have volunteer fire departments in your area. And I don't see any good candidates. But I know that when I was chairman of the county commission in my county, even though it's 160,000 people now, we still had some volunteer fire departments, and they do in other parts of my district. And the way that works is that the volunteer fire department has an area they cover. You subscribe to their help. You pay a subscription fee, maybe $20 a month or something like that. I'm sure it varies from location to location. And if your house catches on fire and they call you, they come put your house out, and your fire out rather. And if you don't subscribe and pay the subscription fee, they still come and help you in the time of need, most of them.
They still come
Yeah.
to respond for protection of life if
Right.
someone is in, but they're not required.
But
to
many
put
of
the
them
fi-
do anyway.
But sometimes they do,
Right.
but oftentimes the degree of involvement in the fire and what it costs them, these are volunteer, nonprofit. They don't have a lot of resources.
So in this situation, somebody calls. If you call them to come and then they send you the bill afterwards that it's in consistent with the guidelines you have in here, and you don't pay, then they have the right for a lien.
That's correct.
Yeah.
Moving
okay.
it from a non-conforming to a conforming.
Okay. Representative Lewinsky, is that you? No? Representative Holcomb?
Yes, sir, Mr. Chairman, and I appreciate your explanation of it. And I'm reminded of a pretty famous case not too long ago, I think just to the north of us in Tennessee, where they had a similar situation where you had to subscribe and they let a house just burn down because they didn't. And so I absolutely support you in this because I think that it will very much promote the public policy goal of having people subscribe. And then if they don't, they can at least, the fire departments can get their money back through the lien. So I think it's a really good idea. Thank you.
Thank you. Appreciate that. Representative Welch.
Thank you, Mr. Chairman. A grammatical question for the committee to consider. Line 17, shouldn't exercise be exercises? Liens in favor of a nonprofit organization or entity, both being singular. I know liens is, but liens aren't exercising the power of the fire department, right? We're talking, the exercise is speaking to the nonprofit organization or entity, am I right? So I think we need to add an S after to exercise on line 17. Got nothing better to do.
Liens don't exercise.
Cool.
You want to ask it?
Just asking.
If they make an amendment, we need to get it right. Yeah. So the conclusion from all our English majors was that there should be an S on the end of it, the word exercise on line 17.
I'm not one of those, but yes, I'm a biology major.
Okay. Well, that explains a lot. All right, okay. Ledge counsel is saying that it's okay. So
He drafted the language.
Ledge counsel thinks it's okay. And the discussion that we were having was that requiring that change would not allow us to get it to the clerk's office today. Therefore, it would.
I'm doing four. Rules committee.
But Ledge counsel, why don't you turn your mic on there and talk to us for a second?
All right.
Mr. Talbot, thank you.
Sure. So the discussion is whether an S should be added to exercise. So instead of saying liens in favor of a nonprofit organization or entity that is exempt from taxation under 26 USC section 501C, which exercises.
Because exercise refers to nonprofit or
Right.
entity, which is in itself plural.
Nonprofit organization or entity would be singular each, which requires the verb exercise.
Which exercise? Well, in that case, if
Scrivener's error, right?
Scrivener's error.
yeah,
Scrivener's error. Error draft.
and
We can catch it in code commission later on.
I mean, if it is singular, then, and I think looking at it now, because you do have the or, then an S should be added to exercise, which exercises the powers of.
A nonprofit organization or entity which exercise.
Because if we say liens in favor of a liens in favor of an entity which exercise, we would say liens in favor of an entity which exercises.
So it should have an S on it?
It should have an S on it.
Okay.
Yeah.
If a court reporter were with us today, I would tell her to mark that down, because this is a prime example of why people don't like to come to judiciary. So it does need an S there. So we're going to put an S there. Okay. So anyone else with us today? Mr. Shelnut, did you want to make any comments? We appreciate you being with us today. Okay. Anyone else? We have anyone signed up to speak to House Bill 387? No? Okay. All right. Thank you, Representative. We appreciate that. House Bill 387 is now with the committee. Is there a motion regarding House Bill 387?
Second.
Move to pass by substitute. Is there any amendments? Mr. Welch?
Are we treating it as a Scrivener's error and he's going to fix it, or do I need to make them? I mean, it's a Scrivener's error.
We can get it changed without having to do anything, and we can keep the same LC number.
No, the LC number has to be different.
Okay, you can just change it. We don't need to do an amendment now.
I'll make the,
We'll just do the amendment. Yeah. Whatever.
all right, so,
I mean, it would have to be a different LC number, so it would be a pass. I'm sorry.
Can you get that done when you get the other one done so we can get to the.
I can have it done now if you like.
Okay, yeah.
Yeah, I can have it done now.
the motion is to amend, line 17 to add an S into the word exercise.
Is there a second? Any discussion? Any discussion? We don't want to talk about this anymore? All right. All those in favor of the amendment, please indicate by saying aye. Aye. Any opposed? All right. Now we have in front of us House Bill 387 by substitute, committee substitute. Any further discussion? Hearing none, all those in favor say aye. Aye. Any opposed? You're now off the rules. Thank you, sir. We appreciate your patience with us
Mr. Chairman
today.
and committee members.
Absolutely.
I'm not sure he can read.
I don't have my bill. When you know it as good as I do. Simple bills. You know it as good as I know it. You don't need to be in front of it. That's it.
Hey, just trust me.
Okay, Ms. Cooper. Chairwoman Cooper, 346, House Bill 346. I appreciate you being patient with us. We're getting a lot of subs done today, and we've just got the copies back, and the copy machine is working fast and furious in there to get it ready. So thank you for being with us today.
Mr. Chairman, I have learned to be patient with this committee, having sat through 12 hours as members of this committee. The subcommittee worked on perfecting this bill, and I'm very appreciative of the time, your time, and of their time especially.
Well,
And
we
with-
know the Trey Kelly, our majority whip, chaired that subcommittee, and I know he was here at 7 one morning with you and the rest of the folks, and here at 8 one night with you and the rest of the folks, and two nights in a row.
2 nights almost, 8
Yeah.
o'clock.
Yeah,
And I'm very appreciative of
Well-
his help and leadership on this issue.
absolutely, and all the committee and staff and folks that worked to make that happen too. So why don't you tell us about House Bill 346?
Okay, and
And the LC we're working off of, Madam Chair, is make sure you have the same one we do, is LC 41-1909S.
Well, and the whip has been kind enough to say that if I would just tell you why I'm bringing this bill, that he would walk you through
Absolutely.
the legal part of it. Since I
Absolutely.
am not a lawyer, and I think this is my first time.
But you
that
did
I've
stay
ever-
at the Holiday Inn last night,
Might be,
didn't you?
you're right, might be
Okay.
successful with
All
coming to
right.
Judiciary or been to Judiciary.
Okay.
Okay, the reason I'm involved in this bill, as you know, I chair the Health Committee. And a year or so ago, we did a study group on stubborn illnesses that face our citizens in this state and high cost issues, and high cost in many ways. And with children, the primary one was asthma, and all the causes of asthma and how many days a year children miss with asthma and the constant sickness. And what we found is that if a child has asthma, it's our biggest return to the emergency rooms, one of the top things for doctor's visits. It accounts to many days lost from school. And if a child misses 15 days of school, whether they are excused or unexcused, their chance of graduating drops by 50%. And in medicine, we do treat symptoms, but we don't want just to treat symptoms. We try to find the root cause of the problem. And here we are dealing in education with trying to stop dropouts, with children going from one school to another being transit, which happens when they are put out of their housing and dispossessed, or whether they have to move because they were in such conditions that they were making their family sick. All of these things add up to one of the problems that we're having in education. And this is especially true with children living in mole-infested houses, rat-infested houses, insect-infested houses. And when their parents, in trying to take care of their basic needs, just to put a roof over their heads, complain to the slum landlords, and I want to say slum because these are not good landlords that we have all over our state. These are slum landlords. When, as far as I'm concerned, they're the lowest kind of humans on the face of the earth. That they would continually just ignore the conditions of what they rent out, and when somebody complains and goes to code enforcement, they start proceedings to evict them. And the problem with that is that when you evict somebody, code enforcement then drops the investigation. And so the landlord is free to not fix anything and just move another family that is desperate to have a roof over their head into the same apartment. You know, maybe they cover up the mole with a little bit of paint, or, you know, do a little bit of cosmetics so that they can't see what the problems are to begin with. And then when the person and the family have lived there for a month or two, the mole begins to come through the paint, and the problems begin to exhibit themselves. And it's the same old thing over again. A sick child, a sick family, they complain, they get evicted. Code enforcement can't do anything. We have a prime example that's happened recently in Cobb County. So because of that, because of my concern for sick children and for what happens to them for the rest of their life, and even studies now show that children who live in places that are rat infested, insect infested, not only are they made physically sick, that the psychological damage to them is significant. And there are scientific studies from good universities that now prove that. And that's why I brought the bill. And I appreciate the work that the subcommittee did. And I will turn it over to the whip. Thank you.
Mr. Webb.
Thank you, Mr. Chairman. And again, I just want to echo the comments that you made, that Madam Chair made, that I appreciate the opportunity to work with her on this issue. It is an important issue for the citizens of Georgia, and I want to thank the members of the subcommittee who stayed and put in the effort to come up with a good Georgia-grown solution to a problem that does exist in Georgia, as Madam Chair just laid out. I'll lay out for the members of the committee kind of what the bill does by identifying the components of it. Lines 11 through 13 set up how a tenant would establish a prima facie case of retaliation against the landlord. You'll see it points to two sections, subsection B and subsection C. Subsection C are elements of the prima facie case that the tenant must take. You'll see some of those things detailed there. Starting on line 25, you'll see the second half of establishing that prima facie case. That would be the actions then that the landlord would have to take. If the elements in B and C are met, the tenant would then have a prima facie case of retaliation. Starting on line 35, we set up some affirmative defenses for the landlord to use against this claim of retaliation. And that continues down to line 54. And in 54, we start the conversation about damages. Mr. Chairman, my goal from the beginning with this was to help establish a claim of retaliation for aggrieved and then dispossessed tenants in Georgia. I think it is a real solution. We have seen some recent news coverage of it, as well as Chief Justice Melton mentioned it to us in the state of the Judiciary, I think a week and a half ago. At the proper time, I do have an amendment that I'd like to make on line 55. As we've worked through this does represent a bill that is in agreement with all the advocates that have worked on this issue. We've worked closely with the realtors and the apartment association, and we've addressed their concerns, and I think they'll be glad to tell you that they don't have any opposition to this measure as well. Again, I'm proud of the work product that's came out of the subcommittee. It has been a very delicate and balanced conversations at time, but that's what we're supposed to do up here. The citizens of Georgia send us up here to deal with real problems, to grind it out, and to come up with real solutions, and I'm proud of what we've done. Thank you.
Mr. Chairman.
Yes.
May I-
Yes, ma'am.
And I want to add my thanks to Aiden Stanley with the apartments and Keith Hatter with the realtors for coming to the table and working on this through all those hours also. And it's such an important issue. One of my commissioners from Cobb County came down, and the Cobb County commissioner sent his personal representative to testify, and all of the other groups that came to testify. I wish Georgia was leading the way on this, but there are 41 other states that have similar laws or laws to help renters, but at least we won't be the last. So I really appreciate all the help we've had with this.
Thank you, Madam Chair. Mr. Welch?
Thank you, Mr. Chairman. A question about line 24. I see that as number 4 as being an element of the prima facie case, is one of 4 options, but I don't know what that means in terms of attempted to establish or participate in a tenant organization.
Mr. Whip, you want to address that?
Yeah, thank you, Mr. Chairman. Chairman Welch, this is what we're seeing is in some of these the most heinous situations, specifically Chief Justice Melton mentioned Thomasville Heights when he gave us a speech, and you may have remember seeing the video where they talked about how they're putting lawyers into school systems now to help address them. Thomasville Heights is one of the worst I guess buildings that this is, communities that this is going on in. And so what we're seeing in that is the individual tenants don't have the resources, they don't have the maybe not individually do they have the knowledge, the resources to try and have any sway with the management or anyone else, and so this would allow them to work as a collective to bring about change inside there. But what we've seen is even in some communities, some buildings where they started trying to get 2 or 3 people together to talk about the living conditions inside the building, that the landlord anticipated that being a problem, and they would go in and evict them just on the presence of them talking. But we do feel it's an important measure for them to be able to do that.
Yeah, and I don't disagree with them being able to associate and form. That's what I'm getting at is that we're saying that a tenant, in this section, subsection B, we're saying that a tenant need only prove that they established a tenant organization
And then
That-
they were dispossessed.
as a result of that.
Yes.
Okay. Do we not think that it's important, though? I mean, so just the association is what we're trying to. If tenants want to associate and come together, we want to, and then they're dispossessed as a result. We want to guard against that in terms of retaliation.
Yes.
Okay. My concern is that just a concern I have is we're talking about the conditions and the environment in which they live, and elements 1, 2, and 3 all speak to that. And this element 4, it's not an element; it's just one of the elements you could allege in order to set forth the prima facie case. Doesn't seem to be congruent with what we're trying to achieve, which is a healthy environment. So it seems to me that tenant ought to make that statement, affirmative statement, take that action, either 1, 2, or 3. But just the association, I don't know why that. I still don't see the connection between a healthy environment versus, as it pertains to element 4.
Well, I'll explain that, Mr. Chairman. It speaks to their living conditions because it allows them to go to the landlord as a group to speak about the shared problems that they may have, and they can realize that there may be more systemic problems within the building than are even recognized, that one person may not realize, but someone could say they realized there's a problem in the entire air handling system that maybe one individual wouldn't know without them talking to the other tenants. And so it gives them a platform to discuss shared concerns or even bring new concerns that would affect the entire group. And that's the connection between the living conditions, is it could help expose to members who are living in it who may just not be aware of something their neighbor may have picked up on.
Representative Dreyer.
Thank you, Mr. Chair, and the Majority Whip explained that very well. Thomasville Heights is in my district, so visiting with these folks, I mean, we can go through all the stories of plaster falling on people as they sit down and water continuing to leak through food areas. But what I found with the very folks that are very unsophisticated and candidly kind of beaten down, they kind of believe that this is their station in life and their condition and there's no other way. And then when they happen to talk to another neighbor and realize, oh, you've got this massive mold leak and your kid is sick as well, what seems to be a good path for them is to put 2 or 3 people together and then walk over and make a report. Unfortunately, they weren't able to get to that second part of making the report, because as soon as 2 or 3 people started talking, they were dispossessed and run out on the street.
Representative Jones.
Thank you, Chairman Fleming. I'm trying to look in the statute right now, and maybe there's someone on the committee or in the audience who knows. Is tenant organization defined anywhere in the statute? No. Okay.
I think I would.
Sorry.
I think I would, to quote a Supreme Court justice, I don't think it's defined, but I think we'd know it when we saw it.
Mm-hmm.
Are we referring to that 4-letter word or tenant organization?
Mm-hmm.
And I think a judge would too.
Maybe not.
Let's put that for discussion.
Mr. Chairman,
Yeah. Representative Welch.
I do understand. I understand the need that sometimes the groups, the formation of and the reinforcement of having multiple people together on the same cause. Tenant organization is just so very broad to me. So what I was thinking was, what would the committee think about adding at the end of, right after organization, at the end of 24, between organization and the period formed to address living conditions or rental conditions or something like that, some qualifier as to why this organization is being formed. I think it needs to be relevant to the conditions in which they're living.
Mm-hmm.
So not for the
Okay.
purpose of like forming a building-wide volleyball team.
Yeah, exactly.
So you want to be prepared possibly to consider that as an amendment, Representative Welch, at the
I
appropriate
think
time?
we take that as a friendly amendment too.
Okay, all right. Other questions of the presenter or the whip who have talked to us about this bill? Do we have anyone signed up to speak to this bill? We don't. No one signed up. Okay. Hey,
Mr. Chairman, I'll
yes,
add that
mhm.
the Chairman Welch said he couldn't find that extra S that needed to be added anywhere in this piece of legislation. So he would add
Would you look diligent? Would you look diligently for a comma though that needs to be changed? We'd appreciate that. Yeah. Nobody signed up. Okay. You used to do that well. Okay. Yes. Yes. Please come on up and come on up with Chairwoman Cooper and we'll turn that mic on for you and introduce yourself for us.
Yes, sir.
Mm-hmm.
Mr. Chairman, my name is Elizabeth Apley. I am here as an attorney on behalf of Georgia Appleseed Center for Neighborhood Justice and the Coalition for Healthy Housing in Georgia, which includes the Georgia Municipal Association, Voices for Georgia's Children, the United Way of Metro Atlanta, the Academy of Pediatrics, Georgia Watch, many other groups. We have a large coalition. We want to thank Chairman Cooper for bringing this legislation up forward on this critical issue, and we want to thank Chairman Kelly and the members of the subcommittee who worked so diligently 10, 11, 12 hours on this to hammer out a solution that was agreed to fully by the Apartment Association and the realtors. We're very grateful for this important step forward to address unhealthy, unlivable housing conditions in Georgia. We see this as a bill to level the playing field between the good actors and the slumlords, and a way to allow code enforcement to do its job.
Thank you so much. I know that you've worked very hard on this and for a long time because I've seen you several times working very
Thank
hard
you,
on this
Mr.
and
Chairman.
for a
I
long time.
thank you for
Yeah,
this.
Madam
Mr.
Chair,
Chairman?
did you want to make a comment?
Just that Supreme Court Justice Melton is from my district and went to school at one of my high schools, and he asked to see the bill. And if the committee so passes this, I will be really pleased to be able to send over the revised copy to him and say that we've made it, at least to rules, and hopefully further on out of the House, since this is an issue that is very special to him, not my bill, but of trying to get adequate housing and for the success of children and better living conditions. for them.
Absolutely. And I thought I brought you up because someone had a question. Was there a question? Okay. All right. Well.
I just wanted to express my thanks, Mr. Chairman,
Right.
to you and to all the members of.
Okay. Good. Good. Well, we appreciate that. Thank you very much. Okay. There's no one else. We have no one signed up to speak to the bill that I'm aware of. And are there any further questions from the committee members for the author? Okay. We'll bring the bill back to the committee now. There's a motion to pass. Is there a second? That'll be by committee substitute. And we have a couple of possible amendments. Mr. Whip, do you want to talk to us about the amendment that you mentioned earlier?
Yes, sir, Mr. Chairman. On line 55, we've talked through this and how this may work in practice, and all sides have agreed with us striking the word complete on line 55.
Striking the word complete on line 55.
We think it'll probably be interpreted that way by the judge, regardless of it being there. And so just for the clear reading of the code, strike complete.
Is there a second? Second. There's a motion and a second. Discussion? Hearing none. All those in favor say aye. Aye. Any opposed? That's in. Chairman Welch.
Thank you, Mr. Chairman. And then at the end of line 24, between the word organization and period, I'd like the committee to consider inserting the language form to address conditions of the buildings.
To address conditions of the buildings.
What's that? Before I had living conditions was, but then Representative Oliver. Either way, I'm good with form to address living conditions, which is what I'd offered before for discussion. Does it matter? Living conditions is a little bit broader, and
Yeah.
and may encompass the grounds, may encompass maybe some of the behaviors, if you will. There could be some.
Say of the property. Form to address conditions of the property. 'Cause I think that's where we were.
Ms. Oliver, you want to enlighten us on this before the chair accepts a second to amendment? Pull your microphone over there, Ms. Oliver.
That's fine.
I'm thinking if you said relative to conditions of the property, it'd be slightly more broad because it could have been formed for a volleyball league and then it came into taking up other issues later. That was my only thought. So my language was relative to conditions of the building.
So form to address conditions of the property, then.
Yes.
She would say relative to.
Right. So we don't have to prove a formation for a specific purpose. The formation originally could have been about the vegetable garden or the co-op or the daycare center. I just don't want that to be, I don't want it formed to be a limitation, is all I'm saying.
Relative to.
Conditions of the property.
Relative to conditions of the property.
That I think that's acceptable to me as far
Comma, relative to the conditions of the property.
I don't think a comma is necessary, Mr. Chairman, but that's.
No. I was not.
I got it in. I got it in.
I was not going to raise the comma issue, although you're right.
We're taking bets over here.
So I'd like to move without the comma.
Is Representative Welch a former English professor?
He thinks he is.
Oh.
Talks about biology.
I like to dissect the bills.
All right, so it would say no comma relative to the condition of the property, correct?
Yes.
Madam Chair? Y'all okay? Okay. Representative Welch has made that in the form of a motion. Is there a second?
Second.
There's a second. Any discussion? Any objection? It's in. Okay. Ledge Council, you got that?
Relative to conditions of the property, or relative to the conditions of the property.
No,
The. Gotcha.
Okay, it was the.
Okay.
Mm-hmm. All right, thank you, sir. All right, any other amendments from the committee for our committee substitute to House Bill 346? Hearing none, any further questions or discussion? There is a motion do pass by committee substitute. All those in favor, please indicate by saying aye.
Aye.
Any opposed? Madam Chair, you're off to rules.
Thank you.
You're welcome.
I have successfully made it out of Judiciary for the first time in all these years. Thank you very much, sir.
Wow.
All right. You can.
But next time you come in, we'll deny it.
All right. Hmm? Okay. So she's here? Yeah. Representative Rich is here? So Representative Rich is here, so I'm going to do her. Is that okay? Just in case. Because the one you're doing is obstruction. Well, he's not here anyway. You want to do yours first or I'm going to do hers first? Okay. Okay. All right. Huh? A meeting? Okay.
I'll be back if I need to come back and do White Hills. It's your.
Well, I'll do it if you come back. Okay.
Should I do it right now?
Yeah, you can do it now.
Let's do it right now.
All right.
I need a copy of the bill.
How is 317 ready to go?
I'd have to ask them.
Can you ask him? No, Trey's got to leave and he was going to present it. Okay, members, you are now having passed out to you House Bill 317, which is on our list today. And Majority Whip Kelly is one of the signers on that, and he is going to present that bill to us. Mr. Whip.
Thank you, Mr. Chairman. I first want to offer my my apologies for Representative Dwayne Hill. He texted me and told me he had to get back home to his district for an important meeting, and really just apologize for not being here to present this. House Bill 317 goes to address a problem that probably many of us have seen in our communities. One where you have some of these organizations that drop receptacles for receiving donated items. And a lot of people think that they're donating them to a charitable organization. Sometimes these organizations aren't even nonprofits. They exist. They collect items and then they sell them. There's all kinds of things that can be done with them. But what we see in our communities is that we see these receptacles not cared for. A lot of times we see them overflowing, and we still see people stacking up items next to them. It becomes a blight on our communities. It makes a lot of different parking lots look unsightly. Sometimes these receptacles are just simply dropped off without even notice given to the property owner. In other pieces of legislation over the last couple of years, I remember us making them have certain kinds of disclosures on the actual receptacles, as well as contact information for who owns them. But what this would do is this would allow your city. This would allow anyone to petition the city, the municipal court, or the magistrate court to issue an order requiring the removal of these receptacles. We're changing that from the Superior Court to the city, municipal, or magistrate court. We appreciate all the hard work that our Superior Court judges do, but this is really one thing not to put something like this for them to have to deal with, and keep something off their plate as they're handling a lot of other important things that only they can have jurisdiction over.
Okay, thank
in
you.
the hopes of getting these dealt with a little, maybe a little quicker.
Thank you, Mr. Whip. Questions from members of the committee? Mr. Whip, this came out of your subcommittee? Chairman Welch, well, I'll address this to both of you then. Was there any discussion in the subcommittee as to why maybe it said Superior Court to start with?
There was, Mr. Chairman. Do you want?
Yeah, just
Want me to rehash that discussion? We have a Superior Court judge here today that might be able to help us with a question, but I'm getting that look again.
Summarize would be the way to proceed.
The issue of the Superior Court obviously gave it countywide jurisdiction, and there was some discussion as to whether or not the orders issued here in the context of nuisance and the context of an order, directive order, may have the effect of a mandamus, which these courts that are identified in this amendment would not have jurisdiction.
Which is along the lines of what I was thinking. Is this an equitable order of any sort?
I'm
not saying that it is. I was wondering if that discussion came up.
We didn't get into the equity issue, but we did. The subcommittee concluded that in attempting to accomplish the objectives of the statute, as well as to not overburden Superior Courts with the immense workload that they have currently with receptacle orders, that we deferred to the author of the bill in allowing local jurisdictions to implement their own local ordinances and enforce them in their respective courts.
Representative Oliver, do you want to comment on that?
In the discussion last night, I raised a similar issue, and it generated some texting back and forth from one of the judges in my area. Well, it's actually Judge Jackson of Atlanta City about the specific issue, and he said that their nuisance statutes gave them some powers. And I was thinking about code enforcement powers that you have, remove this property or I'll cite you for whatever. I do believe in that context they would have additional powers that would be that would satisfy the need of authority under this statute.
And that is the nature of the context. Is it's filed in the context of a nuisance, and we do allow for nuisance abatement at the local level and in local court. And
The magistrate judge is nodding over there.
Mm-hmm. And so, out of curiosity, what would your thought be? Because I'm not sure that I would want to propose it, but simply leaving the word superior and just adding a comma after that so that it could be filed superior city or municipal courts.
that would ensure that you had complete relief in the off chance that someone were to question that. But that
does that create a problem by leaving superior court there?
I don't think it does. I mean, I think that the coverage of the nuisance is sufficient, but at the same time, we don't want to have created a problem that creates effectively a defect in the law.
I was trying to think what would the downside be to having that option.
Might suggest that you put it at the end of that list so that as a reader reads it, they think about going to their local court before they go to superior court, just as a suggestion. Because I don't feel like it's necessary to go to superior court and incur the filing fees that go along with it, and the potential for discovery.
Well, I would very much go to municipal court for several reasons, but I was just thinking of any issues that sounded inequity, and I won't even ask why. Yeah, I won't even go into the whole nuisance discussion, but I don't see it doesn't hurt. It certainly resolves that. So it would read instead to petition a city, municipal, or superior court. Would that be
city, municipal, magistrate,
or municipal or superior court? Yeah, and it would be would it be to petition the or to petition a?
Because you're talking about the jurisdiction, and so there would speak to the singular.
Okay, I agree with you.
The.
So, read that back to us, Mr.
Yeah,
Welch.
So where you see the language appearing at lines 15, 19, and 20, 20, well, it'd be 24, we would strike the or, add a comma after magistrate, insert or superior.
Okay. In those three places.
Yes.
Did you have that, Mr. Talbot?
I do.
Okay.
Just to be sure, it's going to say petition the city, municipal, magistrate, or superior court.
Correct. Okay. Any further discussion? Anyone here to testify regarding House Bill 317? If there are none, we'll bring the bill to the committee.
Move to pass.
There's
Second.
a motion to pass, seconded by substitute. And Mr. Welch, do you have a proposed amendment?
Yes, sir. Yes, Mr. Chairman. At lines 15, 19, and 24, modified the proposed language in LC 41-19-13S to read city, municipal, magistrate, or superior.
Chair takes that as a form of a motion. Is there a second?
Second.
Any discussion? Any objection? That's in. Any further discussion or amendments to the committee substitute before us? Hearing none, all those in favor say aye.
Aye.
Any opposed? Okay. Well, House Bill 317 is off the rules. Okay. House Bill 492, Ms. Rich, you want to tell us about that one?
Thank you.
Thank you, Mr. Chairman. It makes sense that this bill follows after you're having heard of Chairman Cooper's bill. It has come to light that landlords, oftentimes probably slumlords, sometimes are using the dispossessory actions as a sword against their tenants when they are not actually intending to evict them. In the dispossessory process, landlords will request a writ of possession and then will hold that writ for months and sometimes even years without applying for the execution of the writ of possession. So they are using it as a sword to control their tenants. And the magistrate courts are treating this differently across our state. So the Council of Magistrate Courts has requested that we enact legislation that will promote uniformity in the way these cases are handled across the state and will require landlords who have obtained a writ of possession to file an application for the execution of that writ of possession within 30 days of having received the writ of possession. And that is the bill.
Okay. Questions of the author regarding House Bill 492? Is there any questions of the author? Anyone here signed up to testify to House Bill 492? Come on up. Come on up right, Hayden. Introduce yourself and we'll be happy to hear from you.
Thank you. Good afternoon. My name is Hayden Stanley. I represent the Georgia Apartment Association. Appreciate everyone being here for Landlord Appreciation Day. Thank you, Representative Rich, for bringing this. The council has worked with the Apartment Association over the last couple of years to get this in a position that we're comfortable with, and we appreciate you bringing it. We're supportive.
Okay. Any questions? Thank you, sir.
Thank
we
you.
appreciate you being here today. Anyone else here to speak to House Bill 492? That's Mr. Holcomb. Is that Ms. Oliver? No? Oh, Mr. Welch. I'm sorry. I'll just go around the corner then.
Motion do pass.
Motion do pass. Second. There's a motion do pass, and there's a second. Any further discussion? Hearing none, all those in favor say aye.
Wait.
What's that?
It's a sub.
It is a sub, absolutely.
So we need to do pass by sub.
Do pass by sub.
Thank you.
Of course. Motion do pass by sub. All those in favor say aye.
Aye.
Any opposed? You're off the rules. Okay, Ms. Oliver, would you like to present HB 543 to us? Do we have that passed out yet? Give us just a second. We'll work on that. 543.
15. My crew's got it.
Thank you.
Mr. Chair. Chairman Efstration has for a couple of years worked on legislation that has passed the House relative to something that's been called a de facto parent, or in this context of LC 411915S, an equitable caregiver. This 1915S gives discretion to the court, only the discretion to the court, to give standing towards a person who has been serving as a equitable parent of a child, equitable caregiver. I have a number of different examples that have explained this in detail, I think, and I'm just going to cite a couple that's come out of my law practice and law practice of friends, and that is an example of a husband and wife, the biological child of the wife, the father being a stepfather, raising a child together for a decade with the biological father having no role and no participation with the child's life, and the mother dies. The courts, this bill would give an opportunity for the Superior Court judge have an opportunity to consider whether or not the placement with the stepfather would be in the child's interest, but more specifically, would it do harm to the child if the child was not placed with the reality in service father. The language specifically of 543, and I'll go through it in detail, and Chairman Efstration is in obviously another committee, and he asked me to do this for him, deals with a couple of decades of case law that's come out of the United States Supreme Court and at least 3 times in the Georgia Supreme Court in the last 20 years, because it began when I was in the Senate, out of cases involving grandparents' rights. The United States Supreme Court, the Georgia Supreme Court have very, very narrowly defined the opportunity of a non-biological parent of a child to come in to participate as an option for the court to place a child. And this would not apply for any intact mother and father living together with a child. There would be no option for anybody else to have standing. But under 543, in the instances of an equitable caregiver, a person who is defined very specifically in this statute to file affidavits in order to give the court an opportunity, totally in its discretion as set forth in line 26, to hear from the person and to thereafter give by clear and convincing evidence, and that's the requirement of the Georgia Supreme Court for a non-biological father, that the child would, non-biological father yet parent, would suffer, by clear and convincing evidence on line 31, the child would suffer harm. And that language is exactly out of the Georgia Supreme Court. As we discussed this last night in subcommittee, there had been a particular format of the affidavit that the person may choose to file that would be served pleading or affidavit form, and the representative of Stration wanted us to eliminate the form from the consideration and go forward for the committee's consideration today, 1915, that does not include the form. The specific language, the petitioner would have to show the child would suffer physical harm or long-term emotional harm. And upon that finding by clear and convincing evidence, the court has the discretion to award some form of physical custody, legal custody, to the equal parent. Again, this has passed the House in a couple of different forms, and Chairman Efstration wanted to have another opportunity to bring this issue forward.
Questions of Ms. Oliver by members of the committee? Representative Rich.
Thank you. Representative Oliver, do you know if this legislation, if passed, would be applicable to a case that has already, where someone who would have fit the qualifications of this has already gone through the court process and not prevailed because there was not this kind of provision there?
I think it might. I think would be, if I were the Superior Court judge, I would not, I would consider a possible change in the law to be an appropriate opportunity to give standing to a person.
Thank you.
Further questions from members of the committee for Ms. Oliver? Okay. Do we have anyone here that wishes to, anyone signed up to testify on this bill? Sure, come on up. Well, while you're coming up, we'll go to Chairman Welch. Chairman Welch.
To the co-sponsor of the bill, Mr. Chairman, if I may, Representative Oliver, I understand the procedural nature of this bill, but you raised a substantive point in that, and I don't see that in here. I don't recall us talking about that issue, and that was what rights does an equitable caregiver get as a result of following the process? And maybe I missed it, but
Well, if you look at line 45 and 46, appropriate to establish parental rights and responsibility for each individual.
so
I think that would be somewhat broad. The court, again, totally in its discretion, can make a decision. It could be visitation. It could be just participating in a baseball league. It could be physical custody. That's how I read it, and I'm happy for Ms. Carter to give us an opinion if it's different.
no, so it's just intended to be in the court's discretion.
Yes, sir.
Okay. And then the other, these are more points that I just wanted just to verify and make sure the committee is aware that the bill is not intended to alter the parental rights of a family unit where the two parents are together, and the child is living with both parents, and that's covered in lines 47 and 48.
Yes.
And then when there's open case through DFACS, that also will not allow for that interference in that open case. That's covered in subsection F. And then finally, the last one also does not, just because you've been awarded an equitable caregiver position, it does not disestablish, as the bill says, the parentage of any parent. So you don't lose any parental rights as a result of creating the equitable caregiver. I think these are, I just want to make sure the committee is aware that these are important points, because the intent here is not to sever or undermine the parental unit or the parental rights.
That's very helpful, thank you. Particularly paragraph F is something that we've inserted in a couple of other statutes about we don't want any individual family, any individual kin to come in and try to remove a child from an ongoing investigation from DFACS, which it happens fairly commonly that in order to escape that a certain person will come in. Thank you, that's helpful.
Mr. Reed?
And is the Barton Center with Emory, who does with all the child family law, if they reviewed this?
Ms. Carter is sitting here looking expectantly, and she's the chair. Won't you give us your title?
You're Miss Barton?
No,
No?
not that doesn't
Okay.
represent that closely.
All right.
Good afternoon. I'm Melissa Carter. I'm the director of the Barton Child Law and Policy Center at Emory Law School and a clinical professor there. And I really just rise to speak and to thank you all for your work and your interest and consideration of this policy. Had the privilege to work with Chairman F. Stration on this for a couple of years, and then increasingly other members. Appreciated the discussion of the subcommittee last night, and just wanted to again say thank you and lend my request for your support. And if I'm if you have any questions that I can be helpful on, I'm happy to share with you my perspective and the research that we've conducted on this.
Any questions for Ms. Carter? Chairman Welch?
No question, just a motion to pass on the substitute.
There's a motion do pass. Is there a second?
Second.
By committee substitute. Further questions or discussion by the committee? Hearing none, all those in favor, please indicate. No. Else.
LC
No,
4119.
we made no amendments. That's correct. Okay. All those in favor indicate by saying aye.
Aye.
Any opposed? Okay. We're off the rules. Thank you for being here
Thank
today.
you so much. I appreciate it.
The last bill that we have is Ms. Silcox, HB 247. I know that she, like several of us, are hopping back and forth between different committees, and she was here for a little bit, and I was about to call her, and then she got called to another committee. So what I would like to do is, let me see if I can text her and see if she has any idea when she might be able to be back. Oh, can you? Okay. Are you on this one? Okay. All right. Miss Oliver, you would you could present to us House Bill 247.
Thank you, Mr. Chairman. I'm sure Chairman Welch can help on me if I
Absolutely.
but the purpose of HB 247 is to grant some specific authority to law enforcement to have some duties of inspection where there is incidences of elder abuse. If you look at the language beginning on line 48, page 2, designation by the department with consent of any local law enforcement or subject written may act as agents of the department in conducting inspections of unlicensed personal homes as required to be licensed under this chapter. There are folks that can verify. What I have seen in my own practice is very emergency situations where law enforcement are called into personal care homes where there's serious injury or even death of a person, and the inspection unit is simply not available immediately within 1 day or 1 week even to do the kind of investigation that law enforcement is there to do and is qualified to do if they have had a relationship with the Department of Community Health that oversees the licensure of these personal care homes. So there has to be a consent by the local law enforcement. There has to be subject to a written memorandum of understanding between the department and such agencies so that the law enforcement can be an extension, basically, of the inspection units of the personal care homes. It deals with more emergency type situations, timing situations, and criminal investigation situations that passage of this bill would enhance opportunity to bring appropriate charges against personal care homes that have caused real injury or death.
So, Representative Allen, tell me what the law is now and what we're going to make the law.
The law is now that I think if you are a sheriff or a deputy showing up at a house where there's a severe injury of a personal care home or and a patient there, a person living there has been injured or even dead, Department of Community Health may not be available immediately to come in and do an inspection that would terminate the license and therefore protect the other people that may be living in the personal care home. I'm watching Kathy Floyd of the Department of Agent nod as I say this. So they want to close that loop have a better opportunity more quickly, which they don't have right now, to take the license of a personal care home that's done a serious facts of exploitation as defined beginning on line 38 with the new language of line 41.
And Ms. Oliver, please feel free to invite anybody up that you might like.
May I do that, Mr.
Please,
Chairman? Because this has been a good effort for some time by the Department of Aging, and this is a gentleman from prosecuting attorneys, and it's also true that we had 2 hearings on this bill, and we Chairman Welch's help made the definitions more clear about the specific authority of law enforcement and when it was granted.
Well, please, happy to have you introduce yourself, and we'd love to hear from you.
Sure. I'm Kathy Floyd. I'm Executive Director of the Georgia Council on Aging.
I am Will Johnson. I am the State Resource Prosecutor for Elder and Disabled Abuse at the Prosecuting Attorneys Council.
Okay. And so I guess what we were discussing, or the question I'd asked Representative Oliver was, what is the law now and what will the law be after this, and how it differs and how it helps you?
Currently, Chairman, there are less than 20 surveyors around the state for the Department of Community Health to survey all of the personal care homes, nursing homes, assisted living, all of those facilities.
Mm-hmm.
So if an officer has complaints about a place, for instance, people wandering, people without food, unkempt, when they show up, in order to determine the licensure of the personal care home, unlicensed ones are a misdemeanor in this state. They would have to call the department and file a complaint. Healthcare facility regulation is the arm that handles that. It can take up to a week or 2 for a surveyor to get out there. The officers are unsure what to do, how to relocate, because it's different whether it's an unlicensed care home or a licensed care home, which state agency handles the relocation.
Mm-hmm. So am I hearing you correct that we're gonna give the authority to someone who doesn't have it now, the ability to, I'll use the word immediately maybe, and you can correct me if I'm too wrong on that, to shut down and relocate folks who are in what I'm sure is a dangerous situation? Is that what's going on?
Correct. That would essentially, they could immediately determine, law enforcement could immediately determine the licensure. If it is unlicensed, they can place an immediate call to Adult Protective Services, who would
So
relocate.
only an unlicensed location would be affected by this, not someone with a license?
Correct.
Okay, so, I guess that kind of answers one of the questions I was wondering about. You have a nursing home, 50-bed, large facility, however big. They have a license, or they're probably not operating. You don't get that big. Really, in my mind, I'm seeing, a ranch style with 4 bedrooms that someone is using for this. And it takes a while to deal with an unlicensed place that's harming folks.
You could have a house in a regular neighborhood.
Right.
Somebody's, renting and doing this.
But if you have a regular house in a neighborhood that is there legally with a license, so to speak, this is not going to apply to them, right?
No, sir. Then they would
Just
need to-
unlicensed.
Correct. Then they would need to file a complaint with healthcare.
And that's a
facility.
pretty big distinguisher, because I immediately thought to myself, well, we're about to give a lot of power to somebody who doesn't have it. But that's not really it. We're giving power to deal with almost an emergency situation for somebody who shouldn't have been there to start with. Is that fair?
I think that's fair and very helpful. It's also true that elder abuse has become it's been a specific focus of a number of DAs and solicitors, and of course the GBI under Vernon Keenan. They have expanded their criminal investigation of elder abuse issues significantly in my experience with these homes. And they have developed relationships with the licensure people to make sure that they are working together on issues that concern each party in different ways.
Yeah, the personal care homes that are giving good care and following all the rules are angels for what they're doing for some of these people that need help. But I have heard of some local municipalities, in my case, struggling to deal with folks who are not doing a good job. Right. And this would be kind of like the worst of the worst, because they're really doing it, for lack of better terms, on the black market, so to speak. Which, yes, ma'am, go ahead.
Mr. Chairman, your home county is doing a fabulous job, kind of leading the way in this fight.
Yeah, I've heard discussion about it. I sure have. Okay. Any questions? Mr. Welch, did you have something?
I did, Mr. Chairman. I think it's important to understand, or if we could, understand the language we're striking. So I think that needs to be explained to the committee.
On the first page, line 16 through 19?
That's correct, 16 through 19, because we're striking what is now a battery. And so I think that's important for you to hear as a committee.
Okay.
Yes. So when in 2013 the elder abuse legislation was passed that included a felony abuse, the language of the felony abuse is in contradiction and somewhat duplicative of the language of battery of a person over 65. So what this does is take battery of a person over 65 off the books, so that it is either a felony abuse situation or just a regular battery.
Okay.
And in this, I think it's also important to note that if you're referring to 16-5-100, is that cruelty to a person of 65 years of age or higher?
That is the older version. The new version is 16-5-102, exploitation, abuse, and neglect.
There have been a series of bills about criminality of elder abuse, and that's what we're cleaning up right now. That's how I understand it.
Yeah, and I just wanted to make sure that, because there's because the old language did not include the actual physical harm. It was more of an intimidation, neglect, those kind of things, as opposed to an actual. But the new the language that we adopted, I think it was later, in 16-5-102, does actually say willfully inflicts physical pain, physical injury, sexual abuse, mental anguish, etc.
Correct, sir.
So I just want to make sure that we're clear as a committee that the reason why we're moving this forward is when you see that language struck, I didn't want anyone to think that we were removing a crime that we could enforce for physical injury, because that's what it looked like to me, and I need to clarify that in my brain and make sure that we were all on the same page about that. So thank you.
Thank you, Chairman Welch. Representative Walensky.
Either way. Thank you, Chairman. What we're striking says 65 years of age. Under the Georgia Code, is elder defined the same way? Because elder is used in that code section.
Yes, that is correct.
Any other questions from the committee? I don't believe there's any amendments that were discussed, Chairman.
No, I'll make a motion to pass as a committee substitute.
Second.
LC 337866 ERS.
Second.
We have a motion to pass and a second. Do we have any discussion? So we have a motion to pass by substitute and a second. All in favor say aye.
Aye.
All opposed? Moving on.
Are we done, Jordan?
Unless I hear any objections, we adjourn. Thank you so much. Bye-bye.
See my stumbling through.